Further hearing in the appeal in a matter of application by RM of a person under disability by SM, his father, next friend for judicial review.
Mr. McMillan.
Thank you, my lord, ladies. This morning, what I propose to do is to tie up a point about Article 15, where I think perhaps I wasn't sufficiently clear yesterday. Following that, I propose to very briefly look at some passages in 2 or 3 cases, then turn to the materials, including the judgment of the tribunal, and then finish by looking at the judgment then of the Northern Ireland Court of Appeal. Now, in terms of the question of leave, the court will recall that the power appears at Article 15 of the 1986 order, and the court will have seen that at EF 735. May I say that Dr. McLean and I are of the one mind that there is a power to grant leave of absence under Article 15 in the case of Part 3 patients. Now, I think maybe my Lord Seals pointed to the fact that clearly the statute says the RMO may grant to any patient who is for the time being liable to be detained in hospital under this part, i.e. Part 2, leave to be absent from hospital. Just really for the court's note, if I could just trace through where the power, the Part 3 patient power to grant leave appears from. May I ask the court then to turn to first to Article 47 at page 764. And one can see that the cross-heading is powers of the court to restrict discharge from hospital. And at 2, it says, special restrictions applicable to patient in respect of whom a restriction order is in force, as is in our case, or as follows, that is to say, and then C, the following powers shall be exercisable only with the consent of the Secretary of State, namely the power to grant leave of absence to the patient under Article 15.
Secretary of State is now the Department of Justice, is that right?
Yes, my Lord.
Can somebody actually tell us at some stage when that amendment was made and what the provision is that made that amendment, please?
Yes, my Lord. Perhaps
not at the moment, but at some stage.
Of course, my Lord. Thank you. And then we see the provision at 2C, or provision 2, finishes, and if leave of absence is granted under Article 15, the power to recall the patient shall be vested in the Secretary of State as well as the responsible medical officer. And could I then refer the court back to a provision which then amends some of the detail of the operation of Article 15? If the court would go back to the preceding page 763, this is part of Article 46. And at 46.6 is a difficult provision. A patient who is admitted to hospital in pursuance of a hospital order shall be treated for the purposes of the provisions of Part 2 mentioned in Part 1 of Schedule 2 as if he were detained for treatment and his date of admission were the date of the order, but subject to any modifications of those provisions specified in that part of Schedule 2. Now, the use of part in a number of places in that provision makes it slightly difficult. But what that does, in effect, refers one to Schedule 2. And if unfortunately, Schedule 2 was not part of the materials provided to the court in the original bundles. We did ask that the schedule was emailed to the court last night. I'm not sure whether the court yet has it.
No, we haven't.
My Lords, I don't think it's terribly important to take the court to the schedule.
If you can tell us what the relevant provision is.
Yes, my Lord. Simply what it does, my Lord, is it amends the effect of Article 15 to require that, or to permit the Secretary of State to grant the leave of absence, and also, or I beg your pardon now, the Department, of course, and permits the Department to revoke the leave of absence.
Permits the Department to...
Yes, in addition to the Trust, or in addition to the RMO.
Is it the same model as in Article 47 that...
Essentially, my Lord, it is, yes.
The consent. So they can't do it by themselves. The RMO needs to agree as well. Is that right?
Yes. Well, either the RMO, beg your pardon, the Department must agree to the granting of leave. So that's the first requirement. Second difference is that the Department, in addition to the RMO, may revoke the leave.
I see. It can do it itself.
So revoking the leave is then something different from recalling the patient?
Well, I beg your pardon, my lady, you're entirely correct. To correct me on that. It is recalling the patient.
Well, but why then, how then is the provision in Schedule 2 different from what you showed us was achieved by Article 47 2C?
My lady, there seems to be very little difference, to be quite frank, between Schedule 2. Sorry, just find the Schedule 2 there.
What is the actual provision in Schedule 2 which you're referring to?
Part 2, Schedule 2, my Lord, addresses patients who are subject to special restrictions. Paragraph 2 of Part 2 of Schedule 2 says Articles 12, etc., including 15, shall apply in relation to the patient with the modifications in paragraphs 3 to 9. Now,
I'm so sorry. Are you saying that Schedule 2 applies to in cases of patients who are subject to a restriction order?
Yes.
Or so is there something separate that applies to someone who's just subject to a hospital order?
Yes, my Lord, it's the first part of the schedule.
Okay. So Schedule 2, Part 1 is hospital orders, Part 2 is restriction orders,
yes.
Is that right?
That's correct, my Lord. But in terms of this patient, we're Schedule 2, Part 2, and paragraph 2 of that part of the schedule says that paragraph 15 shall apply in relation to the patient, but the modifications paragraphs 3 to 9. Paragraph 3 is not terribly important, refers to a report, Schedule 4. Then at 4, Article 15 says, in paragraph 1, after the word may shall be inserted with the words, with consent of the Secretary of State. So that's the part to grant leave. So the RMO in paragraph 1 of Article 15.1, that has to be read as responsible medical officer may, with the consent of, well, now the Department, grant to the patient who is for the time being liable to be detained in hospital under this part of leave to be absent. So it's interposing simply those words with the consent of the now Department.
Right.
I see. So is this right, that Article 47.2c says that the the Department of Justice can recall the patient, and then Article 46 says the RMO can still recall the patient, but only with the consent of the Secretary of State.
No.
No.
No, I've got the legislation in front of me now.
Yes, so have I.
I've looked it up on Westlaw. And what in paragraph 5, Article 15, paragraph 5b, by virtue of Schedule 2, it reads, it appears to the responsible medical officer or the Secretary of State that it's necessary to do so in the interest of the patient's health or safety or protection of other persons, or because the patient is not receiving proper care. That officer or the Secretary of State may, read short, revoke the leave of absence and recall the patient. So the Secretary of State is, now the department, is able to act independently of the RMO.
Yes, my Lord, that is my reading. So the changes or the amendments or additions to Article 15 occur in the first line of 15.1. So after the responsible medical officer may, then one interposes with consent of the department. That's the granting of the leave. And then, as Your Lordship said, at 15.5b, it says where it appears the responsible medical officer or the department that is necessary to do so in the interest of the patient's health and safety, as the patient's not receiving proper care, the RMO or the department may, subject to paragraph 6, by notice in writing given to the patient, revoke the leave of absence. So those are the three additions.
There's also an alteration to Article 15.6.
Absolutely, my Lord, yes.
Normally, we can see what it says as it applies to most patients, but as it applies to restricted patients, it reads, a patient to whom leave of absence is granted under this article shall not be recalled under paragraph 5, shall not be recalled by the RMO under paragraph 5 after the expiration of the period of 6 months, beginning with the first day of his absence on leave. So the RMO can't recall him after 6 months have elapsed, but the Secretary of State can.
That appears to be the scheme of the Act, my Lord. So, my Lord, that is the common case between the parties of why the Article 15 leave applies in case of restricted patients. My Lord, ladies, may I just take the court very briefly to some of the authorities. Dr. McLean obviously took the court to the key authorities yesterday, but may I just pick up some references to allow a framework to my submissions and to give a grounding to my submissions. Could I take the court again, I think, to the Barking case, which appears at page 854 is the start of the case. Now, this learned friend took the court to this yesterday. This is the decision. The main judgment is from the Master of the Rolls, Lord Wolfe. And could I just pick up a couple of passages very briefly? One can see the nature of the, just from the head note, just pick up the facts from that. The appellant had a history of personality problems and was repeatedly admitted to hospital in an amphetamine-induced psychotic state. One can see thereafter that there was what's sometimes known as a revolving door. She was recovered well in hospital under treatment, took medication, and once she was released in the community, she then suffered another psychotic disorder requiring readmission. So, without going through the facts, if the court would turn to just to see what the treatment was that the court was considering in this case, page 857. Just about a third of the way down the page, what we see from this case is perhaps one of the classic treatment regimes provided in this type of circumstance. We see the appellant was treated with medication. She underwent screening for urine for illicit drugs. She attended inpatient and occupational therapy service and art group therapy. And there was a care program approach involving seeking to reintroduce her into the community gradually under supervision, given the potential risks she represented to the community, etc. Now, we say that this is the normal pattern where one will have this graduated, tapered approach, where one has the reducing involvement of the hospital, and one will spend longer times unsupervised in the community. But we say that that clearly is an acceptable and proper approach. And as part of a programme, we submit that that clearly, in the terms of the English test, is it appropriate that the person is liable to be detained in hospital for treatment. We say that that can clearly be made out. And the Master of the Rules then came to the conclusion at page 861. And after the start of the top of that page, the Master of the Rules is dealing with the submissions from counsel for the patient. Then about a third of the way down, it starts the discussion of the approach and difficulties caused by that. Then about 4 lines down, it says, in such circumstances, the activities which take place as part of the inpatient treatment may all individually be capable of being performed without the treatment taking place in the hospital. Yet the treatment as a whole, to be successful, there will often need to be an inpatient element to the treatment, which means that it is in fact appropriate for him to receive medical treatment in hospital. It cannot be provided unless he continues to be detained. The requirement that the patient has to return to hospital, be monitored, is liable to be recalled from time to time, subjected to the discipline of being treated in hospital as an inpatient under direct supervision with urine and other tests, is an essential part of the treatments that enable the patient to attempt to process rehabilitation in the wider community, which would be more precarious otherwise. The point we make there, just in general terms in relation to that, it is not simply enough, we submit, to have conceptually something which can count as a link to the hospital. In other words, simply because an RMO happens to be at the hospital, that while that may count as treatment, one still must look at the quality and nature of the treatment. And when one looks at that, you're looking at that with a view to, does this link and this treatment, is it of such quality and nature that it justifies the deprivation of the liberty of the patient?
But, I mean, Article 15 doesn't state any such link. It just operates on the concept of whether someone is liable to be detained in a hospital. Article
15, absolutely, yes. But this is the test in relation to the discharge.
Right.
An application to discharge, in our case, under Article 78 and 77.
One of the propositions, which I would be grateful if you could address at some stage, is that this transition from hospital to the community is a vital part of the treatment of a patient. And the only way it can be brought about is if the patient is liable to be detained. Therefore, if that will justify, under Article 77, the patient's detention in hospital so that he can have the benefit of Article 15 leave of absence from hospital. Leave aside significant connection, and that is one method of approaching this case.
Yes, my Lord. We say, my Lord, that's, as the Court of Appeal said, one is justifying the detention on the basis one is being granted leave. And
yes.
One must look at the sufficiency of the reason, but not merely the reason, my Lord. One understands that the importance of testing someone, the potential importance of testing someone. The question is whether the link to the hospital is so important in the regime, Lord.
The link to the hospital is that he needs to be detained or liable to detention in hospital for him to have the benefit of this leave of absence.
Well, my Lord, that would be satisfying the test in terms of the test. The link to the hospital is the supervision of the RMO, in my respectful submission.
Leave aside supervision, leave aside everything else, leave aside significant connection. That in itself is sufficient. This patient needs to have this treatment, which is leave of absence from hospital. In order to obtain that treatment, he needs to be detained or liable to detention, and that is sufficient. As soon as he's made the transition, of course, he doesn't need the treatment any longer, and therefore is not liable to be detained.
Well, my Lord, that is simply, respectfully, to restate the test.
Yes,
say you need treatment.
That's right. It restates the test.
But my Lord, the question is, what is the justification? What's the justification? Or, rephrase it. Is the link put forward a justification? Now, my Lord, when one unpacks this, there would be no treatment of RM in the hospital at all physically. That was never the intention. The only question was the link with the hospital via the supervisory role of the RMO sufficient to justify the deprivation of liberty? And that is the question. And so it's the question of the quality and substance of that link. And we say, my Lord, that that role could be carried out anywhere, whether the RMO is in the hospital, whether he's in another hospital, whether he's in office or wherever. There's no justification or no reason why that supervision has to be carried out in the hospital.
But does he need to be in custody? Is it envisaged that if he goes on Article 15 leave, he will be in custody on that leave? Because I thought that was why it was decided that it couldn't be a condition because of MM. But is that not what's...
No, one doesn't need to be in custody. In fact, one shouldn't be in custody per MM.
No, but I thought that the reason why it was decided that the conditional discharge route was not possible, and so the Article 15 route was brought into play, was because he needs to be in custody when he's out in the community, and that was not possible using the Article 78 route, but would be possible using the Article 15 route.
Well, Lady, that's absolutely correct on the facts. That is what occurred. And the Article 78 route, the conditional discharge route, was found not to be workable. So they went back to the drawing board, and the tribunal reconceptualised the role of the RMO via the evidence of the second doctor, the second RMO. We'll see
So
that.
just making it real, is it envisaged that if this plan is implemented, he will go out to this community place and, for example, at night, he will not be able to leave the facility?
That was the plan, yes.
Yes.
Absolutely. And in fact, when he went out, he would have really one-to-one supervision, certainly in the initial period.
So he won't be able to say, right, I'm going out now. They would be able to say, no, you can't go out until we've got someone to accompany you.
No, my lady. Certainly in the initial period, the plan was that he would have even less liberty than he had in hospital. Though the idea was certainly to taper that down, though I'm not sure whether there was really ever thought that he would move into the community in the way that general population would. It appears that RM draws support and comfort from the services or controls provided to him. But the difficulty is that with the approach put to me by Lord Stevens and of the tribunal and the court at first instance is one's looking at the wrong thing. One's looking at the treatment overall, and I accept one needs to live in the real world entirely. And these clinicians are required to operate in a very difficult or confusing situation in terms of the statutory framework. But saying that, one still must apply the test as it appears. And there's perhaps a good way to really stress test perhaps my Lord Stevens' proposition. Now, as Dr. McLean had explored and developed, the entry test for detention is essentially the same as the exit test. And the entry test in the case of the normal hospital order.
Well, I wondered about that because the word detention in Articles 4 and 12 may mean actual detention in hospital, and the 77 may be liability to be detained in hospital.
Yes.
The concept is that if you're being admitted for assessment or for treatment, you're being admitted as an inpatient. That much of the decision in Hallstrom was approved by the Court of Appeal in Barking. And so I had doubts about whether Article 77 is an exact image, exact mirror image of Articles 4 and 12.
Well, yes, my Lord. You're quite correct that they don't use exactly the same wording. But in terms of a Part 3 prisoner, in my submission, the tests are materially the same. And the test for the entry test as such, one finds at Article 44, beginning page 759. And the court's seen this, and this is obviously on conviction, but of course, per Article 50A, those who have been found to have committed the actus reus but unfit to plead are treated as if a hospital order has been made. But in any event, what we suggest is a stress test. If someone came to the court, perhaps a trust, and said, we would like to admit Mr. X to hospital, and we wish you to admit him to hospital and to be detained on foot of Article 44. The question then, is he convicted by the Crown Court, etc.? And then at A, the first thing is the conditions mentioned in paragraph 2 must be satisfied to commit him to the hospital, the care of the hospital. And overleaf, then we see the conditions referred to paragraph 1A are then A, the court is satisfied on the oral evidence of a medical practitioner appointed for the purpose of Part 2 by RQIA and on the written evidence, etc., etc., that the offender is suffering from mental illness or severe mental impairment of a nature or degree which warrants detention in hospital for medical treatment. Now, could I be a brave practitioner who turn up before a court and say, I wish you to deprive this man of his liberty on the basis that while he's going to be in the community being treated, but the actual order of depriving of his liberty is to be founded in the fact that I'm his RMO and I'm based in a hospital. Now, that would be, the court's much better placed than me, but it would be surprising if a court would consider that that was a meritorious application, and they press the RMO, no doubt, and say, why is the fact that you happen to work in the hospital relevant to the determination of this man's liberty? And just while on this point of stress testing, this is, I understand it, is the Court of Appeal's point on the relevance of leave of absence to the test itself. The Court of Appeal said, in essence, that one could not come before a court and said, well, we can deprive this man of his liberty by order, we're going to let him out, but don't worry, I'm the RMO and I'm in the hospital. And that was the Court of Appeal's point on the leave of absence. So when one thinks in terms of those stress tests and how the tests applied at the entry, we submit that clearly shows that one must look at the nature and quality of the link between the individual patient and the hospital, which is the founding issue. The question that really, again, developed Lord Stephen's point, the question simply isn't, does this man need treatment? It says, does this man need treatment in hospital, in effect? And the answer is, on first blush, no, because he's not in hospital. So then the question is, what's the justification? And that is only the RMO. So the treatment per se is not the issue. The question is the link with the RMO. And we submit that all the cases are uniform in their view, that one does not simply say, in effect, is there conceptually a link? I don't want to be pejorative about this, but a tick box type exercise, one must go on to that second stage. And we submit, ultimately, as we'll see in the materials, that is what Dr. Devine, the tribunal, and the learned judge at first instance failed to do, to go on. They considered that simply because one could class the link as being treatment, that was sufficient, where we submit that that cannot be correct in the case of liberty. Sorry,
I'm not sure how your submission is consistent with Article 15(5) at page 735, because that which we were looking at a moment ago deals with revoking the leave of absence and recalling the patient to hospital.
Yes.
And the test for that is that he's absent from the hospital on leave, but it appears to the RMO that it's necessary to recall him in the interests of patient's health or safety, the protection of other persons, or because he's not receiving proper care. So that may or may not be similar to the test for admitting him in the first place, but it does seem to contemplate that his continued leave, which is not being revoked, he's not being recalled, is on the basis that it's not necessary to recall him in the interests of his health or safety and the protection of other persons, etc. So that seems to contemplate that there can be legitimate Article 15 leave when it's not necessary to have him in hospital?
Yes, my lady, but it's a different question at a different time. Article 15 leave is granted only to patients or subjects in order either...
To patients who are liable to be detained.
Yes, absolutely. They're liable to be detained under the English test, which we've seen, and under the Northern Ireland test as used in some occasions, particularly in Article 15. So one's looking at an entirely different situation, my lady. At the time one's looking at Article 15, whether one wishes to grant leave or revoke leave, one is in a position where an order is in force and the assumption is that it's a valid order, well grounded, otherwise someone would bring an application to set it aside. So accept the general proposition. The language isn't always easy. One needs to think things through, but equally one needs to be always focused on the correct target in the particular circumstances that one's discussing. And one can always perhaps think of difficult situations, but those do not illuminate the current case and the principles we need to apply in our particular case.
Could I bring you back to the test that I was suggesting? And that's based upon Article 77. The words are, warrants his detention in hospital for medical treatment. And the medical treatment which is envisaged is Article 15 leave, which is an essential part of transport. And you can only get Article 15 leave if you are detained in hospital or liable to be detained in hospital. And accordingly, you don't have to worry about a significant connection at all, because the treatment which is envisaged warrants his detention in hospital. The difficulty, potential difficulty with that is it could be applied in other circumstances, and I would be grateful for your assistance about that. For instance, it might be that it is envisaged a person isn't going to take medication, and so it might be thought that in order to compulsorily compel him to take his medication, then he needs to be detained in hospital, released into the community, but always subject to that power to compel the use of medication. That might involve very large numbers of people being compelled to take medication by that route, if that is the correct test. So I was concerned about whether you had any other insights as to whether that test would have an adverse effect read across the mental health order.
My Lords, if I'm right that one looks not merely at the question, is there treatment occurring in hospital? And in our case, it's the supervision of the RMO. In your Lordship's scenario, it's the supervision or administration of medication. But in either case, those matters in themselves, we submit, cannot be sufficient in themselves because they're, in Article 5 terms, entirely arbitrary. There's no need that those matters would occur in the hospital.
Well, if, for example, you had a patient who was discharged on the basis that he had to take Largactil,
Yes.
and he fails to take it, then, and if the assessment is that as a consequence he presents a risk to the safety of other persons, then under Article 15.5, it would be legitimate to recall him in order to ensure that he took his medication.
Yes, but the question is, could he be discharged under Article 78 or 77? And the question is, what is the link then with the medication and the hospital? In other words, does he go to hospital for the administration of the medicine? Does he go to the hospital to check up that the medication has been taken, perhaps by blood tests or urine tests or matters of that type? Does he attend the hospital for counselling?
Well, there might be no link to the hospital at all, except the possibility of being recalled there. I mean, for example, he might be required as a check on whether he's taking his medicine to provide a urine sample to his GP every week, or to the clinic or facility where he's being kept. If it turns out that the tests show that he's not taking it, a report might be made to the RMO, who needn't necessarily be a member of the staff of the particular hospital to which he would be recalled at all. But in the event that he did need to be recalled, if that's a secure facility for mentally disordered patients, that's where he would be recalled to.
Yes, my Lord, and that is a position in very many cases where people are granted Article 15 or Section 17 leave. In the circumstance where they initially begin by having administration of medication at hospital, that may then go out to the community, and they may start off with counselling, and then some of that's transferred. And the question is, where in that continuum one arrive at the situation where the order depriving a person of liberty is no longer justified on the facts? And almost all these situations are progressions or tapering. And as discussed yesterday, one of the best prognostication tools is the testing in the community. And we accept that, but there does come a stage, if one's tapering down to nothing, or no interventions or no administrative medication, etc., there comes a stage.
You're missing the point that's being put to you, and that is, ignore the significant connection test. Just leave it to one side. And the proposition is his detention in hospital is warranted because he's going to receive Article 15 leave, which is an essential part of his treatment. His detention in hospital is warranted because it is strictly necessary that he takes his medication. There may be a balance there to be achieved because some people would present a really high risk if they don't take their medication. Other people, there is a degree of latitude. It's always best to be cooperative. It's always best to persuade. So the strictly necessary test will control any unlawful detention in hospital so that people can be compelled irrationally to take medication. And, so that's the test that's being put to you.
Yes, my Lord.
It's nothing to do with significant connection at all.
Well, my Lord, that would be to justify the detention simply on the basis of Article 15. For example, if the Article 15 leave were to be granted in an extreme situation where there be no input, no checking whatsoever, on the basis that a person was being tested simply by letting them out and hoping for the best, could that then justify the maintenance of the order depriving the person on the face of his liberty? I think what I'm trying to get to, my Lord, your Lordship's proposition to me only looks at one element of the situation, and it only looks at the treatment plan And the treatment plan, we accept one can have a valid treatment plan which includes Article 15 leave, and very many treatment plans appear to have that. But one cannot justify, one still has to be able to justify at all stages that there's a requirement that the individual is to be detained at hospital for treatment.
So you're emphasising the in-hospital side of things?
Yes, I am, my lady. And this importance of the Northern Ireland test, the distinction between being liable to be detained in hospital and being detained in hospital, as Baroness Hale and MM describes the distinction, liable to be detained covers being detained, being on leave, or perhaps...
I think that's a bit of a digression, going back to the whole difference between liable to be detained. I think what's being put to you is whether the Article 15 leave programme, regardless of whether or how much it requires him actually to go back to hospital, should be treated as being within the concept of his detention in hospital for medical treatment for the purposes of Section 77(1)(a), as then imported into, Article 78.
Yes.
So, and I think what you're saying is you accept that it's medical treatment and you accept that it's detention because we've ascertained he's going to be in custody. But what you're cavilling with is whether it's detention in hospital unless the treatment plan itself includes some visits to hospital.
Yes. Simply, we say that the test on its face is clear and requires something that warrants his detention in hospital for treatment. And the flexibility in the English test clearly isn't there, but there must be sufficient connection with the hospital to justify the order and the continuance and maintenance of the order. Now, on my Lord Stephen's proposition, anyone on Article 15, Section 17 leave as part of a treatment plan, they could never effectively be free from the order. The hospital or clinician always say, well, this man has been, for example, in one of the cases, somebody had been effectively on leave from hospital for 7 years, and he hadn't been back to hospital in that period. And the question was his detention, or was he still liable to be detained, or, beg your pardon, was it appropriate that he be liable to be detained in hospital for treatment? And when one gets to that, we suggest like somewhat ridiculous situation, it simply cannot be tenable that that situation could justify the detention order. So the question is, if it's then accepted that leave per se does not justify the order, what other criterion or what other characteristic of the leave, or of the treatment rather, one must look to justify the detention? And that is my point, lady, really on the quality, rather than simply, again, I just can't think of a better phrase, rather than simply a tick box and say, well, yes, we've got the RMO at the hospital, or this is, Article 15 leave situation, so we'll tick the box. One must look at the quality of the connection with the hospital to justify the breach of article.
But is it in this case? Let's just focus on the fact that he needs to be kept in custody, and you can't do that under conditional leave. So his condition is such that he has to be in custody. Now, when you're applying the Article 77(1)(a) test, isn't the correct question, if we don't grant him Article 15 leave, including him being in custody, then his condition does warrant his detention in hospital?
Lady, that respectfully submits conflating the two tests, and certainly Article 15 leave can be part of a treatment plan. And what would in effect occur, say, take a situation where one has a patient, and the patient says to himself or to his representatives, I don't think I should be in hospital anymore, so we'll make an application under Article 78, stroke 77. And the question then appears before goes to the tribunal, and the tribunal says, well, let us look at the situation of Mr. X. What is the situation he is in, and does this justify, warrant his detention in hospital? It's not conceived such that the hospital that will then create another treatment plan. One's testing the treatment plan exists at that particular time. In this case, it just happened to be the situation where the trust brought the matter with the patient before the tribunal at the time a new treatment plan came in, or was being proposed rather. And they said, in essence, we believe that this treatment plan means it's no longer warranted. But the situation your ladyship poses me just doesn't occur, or shouldn't occur, because it's not a case of the hospital or the trust gets a chance to say, no, you can't get out because we're going to change your treatment plan, or something of that nature. You look at the particular situation at the time that the application's made. And if of course, if the Article 15 leave is part of the treatment plan, that can be taken into account. But there's just a vast array of situations where Article 15 can come into play, and to say that, in essence, in all situations, it necessarily means that simply because it's part of a treatment plan, that justifies the continued detention, or the order of detention, simply, we submit, cannot be correct. And it's introducing, we submit respectfully, elements of arbitrariness which just cannot be contemplated either by legislation or indeed Article 5 of the Convention. It's so open, abuse or misapplication that we submit that it can't be conceivably the parliamentary intention. If I may then just rapidly move on to the CS case, which I think it's taken past the Dr. McLean hadn't opens, or just I'd like to refer to, starts at 867. And this is the well-known judgment of Mr. Justice Pitchford. Just the court can see actually what was an issue in Mr. Justice Pitchford's case, the case he considered.
Can I ask you what's the proposition you want us to take from this authority?
That in these cases, the courts do look at the quality of the intervention, and not merely that there is an intervention.
What do you mean by that?
In terms, for example, in this case, the court looks at what treatment is provided and what is the nature of the link with the hospital.
It's the nature of the link. You're taking us to it for the nature of the link to the hospital.
Yes.
I mean, it's a proposition that that this case vouches that there must be a connection between the treatment and the hospital. Is that the proposition?
Well, no, my lord, that's the first stage. There must be a link between the patient and the hospital. The second stage is it must be of sufficient quality and substance to merit the order, or the continuation of the order. And that is essentially Mr. Justice Pitchford's point as to the Gossamer-Thin connection with the hospital at the end. It's a tapering situation.
And what order is it we're talking about? You say there must be a link between the patient and the hospital of sufficient quality and substance to merit the making of the order.
Yes.
What order?
Sorry, I beg your pardon. To merit the continuation, in other words, the refusal of the discharge. Sorry, my lord.
Right.
I won't take the court through the history, but this was a patient who had little insight into her condition. She had an established record of non-compliance with medication disengagements. Just the court's notes, really, tribunal's reasons are 27, page 876. The learned judge carried on 879, correctly 32. Detention under Section 3 is not in practice necessarily residence in the hospital. What it means in practice in any particular case will depend on the regime in force. We accept that. And then talks about various types of leave of absence.
The Court of Appeal in Northern Ireland didn't.
Beg your pardon?
The Court of Appeal in Northern Ireland didn't accept that proposition. They said that it was a binary choice. Articles 4 and 12 presented a binary choice, namely detention in those articles meant detention in a hospital, inpatient treatment. That's what the Court of Appeal in Northern Ireland said. And it's also what the Court of Appeal in England endorsed in the Barking case.
Well, my lord, we wouldn't go that far. The question is, does it warrant detention in hospital?
The detention under Section 3 was held in Holstrom to be actual detention in hospital.
Yes.
In Barking, that was approved. That part of the judgment in Holstrom was approved. I'm not certain where this proposition comes from.
Well, my lord, of course, Mr. Justice Pitchford deals with the Barking case 39 onwards, 881. Says the word detained has been construed according to Lord Wolf's guidance in Barking, and therefore the first question can be refined to: was C's mental illness of a nature or degree which made it appropriate for her to receive treatment, a significant and justified component of which was treatment in hospital? And it looks at DR. And it,
So is that what you say is the test?
yes, in essence, milady, I do. One must look at the.
I'm sorry, which paragraph was that?
Sorry, my lord. Paragraph 39 at the foot of 881. A little uncomfortable with replacing statutory wording with a test of significant justified component, but clearly that those are intended to be indicators of the type of matters that will meet the statutory test. But certainly there must be a significant justified component of which was treatment in a hospital. And if one applies it to the terms of this particular case, what was the significant justified component of which was treatment in a hospital? And that was the presence of the RMO. The only matter in this case was the presence of the RMO, who was supervising the testing of the individual in the community institution, community setting.
I mean, obviously, the facts of different cases differ.
Yes, my lord.
In our case, it might be said that the question is whether RM's mental illness was of a nature or degree which made it appropriate for him to receive treatment, a significant justified component of which might be treatment in a hospital, because he, although he might be granted leave, he's always liable to recall. You know, it's looking forward, and one can't predict with certainty what's going to happen.
Yes. Lord, that is correct, but again, the link in the statutory test between warranting detention, the detention be warranted by the fact of the need for treatment in hospital. And on my submission, and the quality matter must mean that it cannot simply be left to something, the happenstance of where the RMO is based. And I think I mentioned yesterday, what if, for example, the doctor was transferred?
Does that make any difference?
Yeah, I mean, doesn't that have a tendency against your argument? See, I mean, if I may, and it's really following on from what my lord has said, if one looks at Article 77(1)(a), which this is page 781, I'm sorry to take you away from this authority since we're debating this. 77(1)(a) requires the tribunal to look to see whether someone is then suffering from mental illness or severe mental impairment, which warrants detention in hospital.
Yes.
Now that's looking at the underlying condition of the patient. Now, it may be a case, and again, my lord was putting this example to you, of someone who, if they take their medication, will not be subject to florid symptoms. They'll still be suffering from mental illness or severe mental impairment because they have to take the pills in order to avoid the symptoms which will cause danger to themselves or to the public. But if the tribunal is looking at someone who is in that condition, surely Article 15 leave and the use of that is being used to test whether that underlying condition has either disappeared or is sufficiently constrained. Now, if the Article 15 leave happens not to work out in the sense that it doesn't give full confidence that they're now free of the disease or can be completely relied upon to take their medication, then the underlying position is that they are suffering from mental illness or severe mental impairment which warrants their detention in hospital.
Yes, if the Article 15 leave doesn't.
Yeah. So Article 15 is there being used in that context as a test to see whether this underlying condition continues to be fulfilled. The fact that it's being used doesn't show that that underlying condition has gone away. It's testing to see whether it has gone away.
Yes, Lord, we've never suggested that if one's in Article 15 leave that can't be the detention cannot be justified, or the continuation of the order cannot be justified. The question is not merely is one on Article 15 leave or not on Article 15 leave. That isn't the final analysis. Article 15 leave is only part of the treatment. The question is then the connection.
Right.
And
so on the connection point, in the account that I've just given you, connection with the hospital isn't part of the test, other than that if the Article 15 leave doesn't work out, someone can be recalled to hospital. That's the only link with the hospital that you need. If it turns out that they become florid again, they can be recalled to hospital.
well, my Lord, that's effectively changing the whole philosophy of the legislation from treatment to some sort of preventative containment. If an individual, your Lordship's posited the case, if the individual is in a situation where their symptomology has resolved to the extent that their detention is no longer warranted in a hospital, one must discharge, and simply because there's a chance of some stage in the future.
I'm sorry to interrupt you, but how do you account for Article 15 then? You've got the person in hospital, they're taking their drugs. At that precise point in time, they don't have florid symptoms.
Because
Are you saying that they have to be unconditionally discharged at that point? What's the role of Article 15?
well, my Lord, it's part of a treatment plan, and it's when one gets to the tribunal, make an application for discharge, one doesn't simply say, on this day, how are you? It's how does it fit into the entirety of the treatment plan and the progress. Now, the cases have rejected this, it describes atomistic approach of only looking at one feature at one time. One looks at the matter in the round and says, when you're on Article 15 leave, this Article 15 leave is part of your treatment plan, and that is the justification. But the issue then is, if one gets to a stage where, say, for example, didn't have symptoms for a number of years, and one's perfectly well, we would submit that there would have to be a discharge, whether it's conditional or absolute discharge, would have to be a discharge, because these simply would not be, the continued detention or the continuation order would not be merited simply on the basis of some prospective difficulties. In one case, a lady had a peg tube for feeding, and everybody knew she'd have to go into hospital to get it taken out. That wasn't enough. And many of these individuals we see from the cases are vulnerable to this so-called revolving door going in and out. But that in itself, my Lord, is not what the detention.
But you're not at that stage yet. And that's why we were discussing yesterday how soon after you've been
Well, we respectfully.
you can say, look, I'm doing perfectly well. Now I want to be conditionally discharged. But your client's not yet at that stage.
Well, we respectfully submit, lady, that in terms of the test, what part of his future plans from the future engages the hospital, and that is the presence of the RMO.
Well, if he has to be recalled, that will engage the hospital.
It may not have to be recalled.
Yeah, he may not have to be.
Well, yeah, but again, my Lord, one does not maintain an order simply on the basis of what may happen in the future. One certainly.
That's precisely why you maintain the order in place. It's all about management of risk. That's precisely why you maintain someone subject to, if it's a Part 2 case, subject to medical supervision. If it's a Part 3 case, it's a combination of medical supervision and now the department.
Well, my Lord, it's not simply a question of risk. There are two parts to 77.1, and we have A, which is the question of the treatment issue, and we have B, below AA, tribunal is not satisfied that the discharge would create a substantial likelihood of serious physical harm to himself or other persons. So that's the risk element. And they are divorced from each other conceptually. Both tests have to be met for discharge to be refused. And it's not an all or nothing thing. If, for example, the tests aren't met, 71A and B tests aren't met, then we're in the situation of a discharge. The question then is, can be conditional or an absolute discharge, which is determined by 78.1. So many conditions can be put on a discharge. And those conditions, lawful conditions, of course, can be directed towards controlling risk. But equally, even if...
I'm not quite sure what point you're making now, because on the facts of this case, the tribunal didn't get to that stage. It wasn't satisfied so far as the first part of Article 78.1a is concerned.
Yes, on the basis that
get into the 78.1b.
On the basis the RMO is going to be based at the hospital. That's the reason they didn't get on to the second question. But I understood, my Lord.
I'm not sure that's a fair reading of the tribunal's decision.
Well, my Lord, if I may just park that comment. Sorry, my Lord. I'm just trying to engage your Lordship's question. Yes. The reason why I went on to the other matters, because your Lordship is raising the question of risk and controlling risk. And controlling risk is may be controlled not merely by the continuation of the order itself, but by other matters post-order, one being conditional discharge. And of course, in many cases, one takes a certain degree of risk in discharging anyone. But if the person develops or expresses symptomology in the future, another application can be made for hospital order. I appreciate that can be onerous and more onerous than simply keeping them in hospital, but that is the regime we have. And
if you'll forgive me, it isn't. Because if they're released under Article 15, there's a completely separate mechanism for recall to hospital. You don't have to go through the whole process of setting, of making an Article 12 or Article 4 assessment de novo.
Yes.
If you're in the Article 15 regime and it hasn't worked out, someone can be recalled to hospital under that regime.
We've never disputed that. That's correct, my Lord. But things move on, and we say that RM had moved on, and all these cases are progression and tapering off, using that language of the cases. And we say at some stage, you just can't say, oh, well, just going to keep you on Article 15 leave.
If you'll forgive me for saying so, you seem to be making a point on the facts now, but as my Lord the President pointed out yesterday, this is not a case about the facts. The facts were determined by, on the evidence of Dr. Devine, by the tribunal, and according to their factual determination, your client is still suffering from a mental illness which warrants his detention in hospital and is still a threat to the public.
Well, my Lord,
those are the facts.
Those are the facts, my Lord. And I'm not asking the court to go into the facts again, other than to say that finding was not merited on the basis merely that the RMO happens to be based in the hospital. And if that is sufficient, my Lord, we submit that it's deprives the provision and protections of the statute of any real substance. One can simply say, well, we're maintaining the order because where the doctor happens to be physically based.
Yes. Now, you'll have to forgive me because I took you off your the development of your submissions on, I think it's the CS case.
Yes, my Lord.
You're at page 881, so forgive me for that digression.
And not at all, my Lord, it's helpful to expose the issues. In any event, my Lord, I think the court really has my points on these cases. You saw them by Dr. McLean's submissions yesterday. And in general terms, we make the point that these cases are tapering off, and there comes a time when someone will cease, even in the course of a treatment, to no longer merit, or arrive at a situation where the maintenance of the order is no longer merited. Just one authority could I just refer the court to very briefly that wasn't referred to yesterday. I think it was DB at 836. My notes yesterday were slightly imperfect, but this case of DB in the Bessie Cadwalder University Health Board. Just only a couple of points to pick up on this. For the sake of completeness, see the facts in my head note: the patient was liable to detention, hospital, mental health grounds under Section 3 of the Mental Health Act 83, but had been allowed on supervised leave in the community pursuant to Section 17. He was living in the care home where he was complying with the treatment regime, and he had not needed to attend the hospital for the past 11 months. Then he applied for discharge under Section 77.
And what's the proposition we're going to be asked to take from this case?
Well, again, to support my general proposition, my lord, and the upper tribunal in this case considered that it was an error of law to consider that the...
Grateful, sorry, the proposition is being advanced.
Sorry, my lord.
Sorry for asking.
Forgive me, my lord. The proposition being advanced, the primary proposition is to...
But what are we to take from this? I mean, why are we looking at this? Another way, a less polite way of putting the question.
We're looking at, my lord, to see the way the upper tribunal handled it.
I'm not just interested in how the upper tribunal handle cases. We're trying to find out what the law is.
Sorry, my lord. Could I take the court then to 13, which is the key passage? And it's simply the tribunal's, upper tribunal's commentary or comment or point. 4 lines down, it talks about the tribunals think you're not liable. Detention is not a fallback when the possible options are not suitable or not available. To repeat, if the statutory conditions for detention are not met, tribunal must direct their discharge. That's the height of the point, my lord. We submit that in effect, my lord, that is the situation based RM. In this case...
That's not what the tribunal found.
No.
It didn't find that the statutory conditions were met.
On the basis...
Or were not met, sorry.
Yes. On the basis of where the RM was based, milady.
Well, so you say that we...
Well, milady, it may just then take the court...
Well, we've got your point that it's important where the RMO is based. We've, I think, been round that particular key quite a few times.
We have, my lords, yes. May just then take the court to the decision of the tribunal at 531. And again, the court has seen that developed by Dr. McLeanan. So the court knows exactly what I say on the issues. And really this point, and we can see what the have seen the evidence, and that's discussed by the tribunal at 37, top of that page. I won't take the court, of course, through
Sorry, which page?
541, paragraph 37 of the judgment. Sorry, my lady. This is the evidence.
Looking at this, the tribunal held that there was a sufficient connection. You are seeking to apply the sufficient connection test. There's no cross appeal to say that the tribunal was incorrect and that they incorrectly said there was a sufficient connection. I mean, the issue just simply doesn't arise.
Well, my Lord, the judicial review to the High Court was on the basis that the tribunal was not entitled to come to that view. So that's really, in judicial review terms, our proposition.
Are you talking about an earlier stage in the proceedings? I mean, before this decision? I mean, what judicial review are you talking about?
Of the came before Mr. Justice Colton.
Oh, I beg your pardon. I thought that was. I'm sorry. I've lost track of this. I thought that was I thought that was a statutory appeal.
No, my Lord. No, it's judicial review.
Thank you.
Forgive me, my Lord.
My fault.
Sorry, forgive me. Just back to paragraph 37 of page 541. This is the tribunal recounting the evidence, and court's seen this. We've seen halfway down Dr. Devine's suggestion that submission that Article 15 would allow rigorous testing out of the care plan. He was then questioned about his divergence with the other doctor, and his point was that the other doctor who'd said that the treatment was complete and discharge was merited, he failed to take account of the medical supervision which Mr. McFadden would require in any move out of hospital, and that he clarified Dr. Devine clarified under Article 15 leave, the RMO would direct what conditions were to be applied to the patient, but such leave was subject to the department approval. So the supervision that was to be carried out of and treatment was all to be provided at the facility of Knockcairn completely. So the only difference in the view of Dr. Devine compared with Dr. Milligan is his view that the supervision by the RMO was sufficient to account.
But Dr. Devine says there was uncertainty as to how RM would cope in the community. And no doubt that meant that the need for having the possibility of recall to hospital under 15.5 remained.
Not necessarily.
Well,
but it's the issue is not is there a need for recall to hospital. The question is there treatment or is it?
Well, that's the question. Which of those is the question? That's what.
Beg pardon, lady?
That's what we're trying to decide. Which of those is the question?
Well, yes, my lady. And we submit that the position is very clear. One comes to the before the tribunal. One looks at the treatment plan in the round, and the treatment plan in the round is that everything classically or normally called treatment is being carried out in the community facility, Knockcairn. Now, the other thing, the one matter that's not being carried out is the supervision by the RMO from the hospital. And the issue then is, was the tribunal entitled to come to a view that that was sufficient? And we submit what the tribunal did. The tribunal effectively said, oh yes, Dr. Devine has been able to identify an issue which can amount to treatment, and we believe does amount to a treatment, and therefore, because we have that connection, that's the end of the matter. And our complaint about that decision and that reasoning is it does not go on to look at the sufficiency or the connection or the quality of the link. And that is fundamentally...
But surely the point being made by Dr. Devine is RM needs to be tested in the community. We'll use Article 15 leave for that. If it doesn't work out, he will be recalled to hospital. As I was putting to you before, isn't that the link with the hospital? Because that will show, actually, his mental illness is of a character which warrants his detention in hospital, and moreover, he does have to be detained. We've tried under Article 15 to see if he can cope outside, and he can't, and he needs to be detained.
Well, yes, my Lord, again, I'm sorry, I don't want to repeat myself about the question of that may be, in many cases, and perhaps most cases, at the start of the Article 15 leave, perfectly tenable position. But in this case, it simply isn't, because the lack of connection with the hospital, any meaningful connection, other than the chance of...
That's what I'm seeking to press you on. You seem to think that under this regime, the connection with the hospital has to be through the RMO, whereas what I'm putting to you is, under this regime, the connection with the hospital is what happens to the patient if the trial period under Article 15 doesn't work out. They have to be detained in hospital. That's the relevant connection with hospital. And I would welcome your comment on this possible proposition that that's the only connection with the hospital that is required under this regime.
Well, my Lord, then that would mean that any time, so long as anyone was released on leave, that was sufficient to justify the maintenance of the order. Now, that has never been the conclusions of the cases. The cases, I submit, uniformly recognises tapering down, and at some stage, with tapering down comes so established and so overwhelming that the order is no longer justified.
The tapering down works fine if everything pans out as everyone hopes that it will, but it may not. The tapering down may taper down, and then suddenly you're back into very florid symptoms, and the person has to be recalled to hospital. It's just...
Sorry, my Lord, perhaps I didn't explain the point very well. What I'm saying on that point, my Lord, is at the start there'll be a lot of interaction or intervention or physical treatment at the hospital. And that at that stage, certainly that circumstance can justify the maintenance of the order, continuation of the order. But it will get to a stage where even if somebody's still on their Article 15 leave, the connection with the hospital is so diluted that the order can no longer be justified. And that is the stage we were at.
It's not diluted if they're recalled to hospital. It's very undiluted then.
Well, that's in the future, my Lord. That's not the situation at the time. One needs, we respectfully submit, look at the situation at the time. And of course, one looks at risks factors, and that comes in particularly in relation to the safety, public safety aspects of the case. But when one is analysing where one is at any particular time, you're looking at the matter in the round, where we are, and there will always be risks.
At the time of the mental review tribunal, where was RM?
He was still in the hospital.
He was still in the hospital. The leave hadn't started at that point.
No, it started about 6 weeks after, on 29th of March, beg your pardon, 2021. And it was said to the court, he's been there ever since.
So when he brought his application under Article 78, he was still an inpatient in the hospital?
He was, because he hadn't been released.
Yes.
But it was first application. But he had been out on leave over Christmas, and had been out on various unaccompanied shopping trips. So it's not quite correct to say that there's no testing, but it's a very modest amount of testing. But he was in the hospital, and that's the nature of many applications.
But I mean, it'll presumably also be the nature of many applications that people make them while they're on Article 15
Absolutely,
leave.
yes, of course, my Lord.
You know, the fact whether he's in hospital when he makes the application or out of hospital when he makes the application is neither here nor there.
Well, absolutely, my Lord. And our point is that simply because one can be in Article 15 leave does not mean that there's a justification per se for the continuation of the order. One still needs to look at why, what the nature of the connection. And if the nature of the connection is simply the presence of the doctor,
Yes, thank you.
Your Lordship has my point. And the court has
Can
seen...
I just ask a factual question? Is there another right to go to the tribunal or another application that a patient can make if they say, for example, I want to be out on Article 15 leave, and the RMO refuses? Is there some other provision that says you can apply to the tribunal for that?
I don't believe so, my lady, short of judicial review, which
I see, yes.
I think would never really get anywhere. But there's no, as far as I'm aware, it's no statutory mechanism.
Right of appeal.
Just to return to the decision, the court again has seen that 543 in paragraph 41 is really the key passage. But 8 or 10 lines down, clear to the tribunal on the evidence that treatment will have to continue in the form described by Dr. Devine. That should be continued while Mr. McFadden is still subject to detention till such time he does not require detention in hospital for medical treatment. And we ask, what's medical treatment? And the key point is the tribunal accepts the evidence of Dr. Devine and Dr. East that the oversight, care and risk management described by Dr. Devine does amount to treatment. So that is what we respectfully submit, reading fairly, is what the tribunal found. The difference between Dr. Milligan and Dr. Devine was simply on whether the role of the RMO amounted to treatment, and they say it did amount to treatment. And our complaint is earlier.
I don't think that isn't only a reference to the RMO, is it? The oversight, care and risk management described by Dr. Devine. Didn't he talk about quite a lot of people being involved in?
Well, my lord, all the other people were at Knockcairn.
Yes, exactly. I mean, it's part of a treatment plan devised, I suppose, by those responsible for the patient's treatment at the hospital, but people actually executing the care and supervision and so forth are going to be at Knockcairn.
Yes, my lord. But again, my lord, we're back to the connection issue again. Can it be correct that simply because a treatment plan is devised in a hospital and executed elsewhere is sufficient connection with the hospital to merit the detention of the... Again, we're back to the happenstance of where the treatment plan is devised, but the substance of the treatment is outside the hospital.
Yes, I think the passage in paragraph 37, it says that Dr. Devine's evidence was a lot of personnel would be involved in assessing the patient's care needs and ongoing risk assessment and providing regular refresher psychological support. His role as RMO would be to have oversight.
And those are the staff exclusively at Knockcairn, my lord. Sorry, I didn't want to take the court to the treatment plan, but there's nothing, as far as I can see, and we've been made aware of, where there's any elements of what one would normally call treatment or supervision conducted anywhere else but Knockcairn. There was an attempt to, for example, just to be absolutely clear about it, maintain some continuity of provision of treatment. So the idea or the conception was that, for example, the clinical psychologist in the hospital would go and carry out work at Knockcairn with RM. But other than that situation, everything was being provided at Knockcairn. So the court clearly has my submissions on the decision of the tribunal. Just turn to the decision of the Northern Ireland Court of Appeal, if I may, just finally. And that is at page 221. And again, Dr. McLean's opened this to the court, and I will not trouble the court with, I think, the facts. And up to really paragraph 20, which is on page 229, the court simply recounted the background and the events leading up to the hearing before the court and the hearing before Mr. Justice Colton. And 20, the court raises the question as to the differences in the legislation, and we respectfully submit that neither the Dr. Devine or the tribunal or Mr. Justice Colton grappled with the issue as to what was meant by the use of different wording when one compared it with the 1983 Act.
Well, they're hardly to be criticised if the point wasn't raised. The implication of paragraph 20, the first sentence, is that this was a point that the court raised, the Court of Appeal raised.
Yes, my lord, I recognise what the court says, and there was some certainly some confusion on that and different viewpoints, but that's what the judgment says, my lord, and I accept entirely what the judgment says on its face. But the court raised that point, and your lordship is quite correct that the issue...
Well, they go on in the second sentence, say despite raising it, they got no submissions.
Yes.
But undaunted, they've dealt with the point themselves.
I did not take that as a hint that there was.
Well, my lord, I didn't appear below, but I'm advised, my lord, that certainly I think the recollections of counsel did appear, from my understanding, didn't accord with that. But we are where we are with the judgment, Lord. Yep. I don't really wish, if I may, Lord, to look at that particular issue. But certainly your lordship is quite correct that on its face the issue of the difference in the legislation was not raised with the tribunal and the lower court. And we submit that no matter which test be used, the facts of this case could simply never allow for the continuation of the order.
Sorry, can I just be clear? I thought that your position was that the differences in the legislation didn't justify a conclusion that the English test is less onerous.
Milady, both tests bring in the necessity issue.
They're both necessity tests.
The issue then is, where does necessity bite? Now, it could bite in a number of ways. It could bite and say, well, the detention must be necessary. Or it could bite by saying that the Northern Ireland test would be that it was necessary that someone's detained in hospital for medical treatment, and the English test could bite in the sense that it had to be necessary that someone was liable to be detained. So even though the necessity can be brought into both tests, or must be brought into both tests, it does not necessarily lead to precisely the same conclusion. Or this, rather, the same operation, or the same test in itself. But the Court of Appeal, it appears to be unhappy generally with the proposition that a gossamer thin connection with the hospital could be enough. And I accept entirely that the court may not have done full justice to the decision of Mr. Justice Pitchford, where the gossamer thin test was just the or the stage was just the very final stages, and indeed that the court did not look at the English cases, set them out in detail or analyse them on the basis of the judgment. But what the court did, in essence, on, I would suggest, the assumption that there's some sort of justification on the basis of a Gosforth connection, the Court of Appeal then looked at the Northern Ireland test from first principles. It simply turned to the test and the court then analysed the test simply on the basis of its wording. And the court looked then at various instances where different wording was used in Northern Ireland as compared to the English legislation. And in many of those instances, it wasn't particularly important or particularly relevant. But ultimately, it found then that I think really 32 over towards 33 encapsulates my point just after the quotation from Mr. Justice Pitchford. Mr. Justice Pitchford was of the view that the degree of grasp of a hospital consultant, or other hospital-based consultant professional, or a patient may be Gosforth within, but such grasp may be significant, and that is the key criteria. That's perhaps not necessarily a completely fair reading. However, this does not mean that the differently worded provision in Northern Ireland legislative scheme should be interpreted in the same manner. It is the view of this court that it should not be. So the assumption appears to have been that that was the test, as the court stated in that subparagraph, was the test in England, and the court in effect rejected that. And it perhaps may benefit from a fuller discussion of the English cases. But in any event, the court then carried on. We submit an entirely conventional way, and at 34, page 234, it set out the sequential nature of the test, which we submit is perfectly correct. Paragraph 34 talks about 10 lines down. Firstly, the review tribunal must ask itself whether it is established that the patient is suffering from mental illness. That's not in dispute. Secondly, whether it's amenable to medical treatment. Then 3 lines up from the foot of the page. Thirdly, if the matters are established, the review tribunal must consider whether the mental illness, etc., is of a nature degree which necessitates the person's attention in hospital for medical treatment. So that's where they put the bring in necessity. And they said, carrying on in relation to the third question, it's obvious that trivial and functionally insignificant conditions whenever warrant attention, etc. Then about 5 lines down, but the test is more stringent than that. There must be demonstrated that the detention in hospital is necessary in order to effectively provide the envisaged medical treatment. In other words, detention cannot be justified. The envisaged medical treatment can be effectively provided in the community setting. And we submit in quite clearly, RM's treatment can effectively be provided in the community setting. And that has been demonstrated over the last 2.5 years. And then, of course, the court carries on into the discussion of the operation of the leave of absence. And I think I've really made my submissions on that earlier, in the sense that the court, in fact, my stress testing example, one simply cannot come and say, well, we're going to grant leave of absence, so that in itself means that one must be detained, or the order must be maintained. But at 40 over leave 236, we see that the court recognises there's no doubt that the option of Article 15 leave of absence for a detained patient is an important and valuable therapeutic tool. Nothing in this judgment should be interpreted as meaning the court is seeking to place obstacles on the legitimate use of the Article 15. However, Article 15 should not be used as a mechanism for providing legitimacy to what amounts to detention in the community when the grounds for detention, hospital for medical treatment, no longer exists, and cannot and should not be seen as means of avoiding difficulties presented by
The question is whether they did come to the conclusion that the grounds for detention in hospital for medical treatment no longer existed. And the Court of Appeal seems to be saying the very fact that you're thinking of giving him Article 15 leave must show that the grounds for detention in hospital for medical treatment don't any longer exist.
Well, Article 15 leave could obviously only apply if the grounds for detention do exist. And the way the court recognises clearly the valuable role played by Article 15, but I would submit they get to the nub of this case, that the Article 15 was used, and I don't mean to be discourteous, but this is a device to get around the perceived difficulties brought about by MM. And one could perhaps understand from the perspective of RM and his father the confusion as to how matters changed from the first hearing and the adjourned hearing when Dr. Milligan's evidence was considered to this particular stage. And one tries to explain to them how the presence of Dr. Devine and Dr. Devine's view changes the position. It's not an easy matter to describe or to explain to them, and we submit that, in effect, the Court of Appeal understood the position properly. Is there anything else, David? Yeah. Just may happen. Sorry, excuse me, Lord. Just have. Sorry, what is it? This is the application for. This is the application to the. My Lord, just for completeness, in relation to the issue as to whether the question of the difference in the two legislative schemes, the wording schemes, was raised, could I briefly take the court to EF page 58, and this is the application of the Review Tribunal's application to this court for leave to appeal.
Stand by, a review tribunal is actually appealing. Judges don't usually appeal their own decisions.
Absolutely.
I was going to ask Mr. McGleenan why we had so many appellants in this case. Anyway,
yes, and in fact, the trust didn't seek leave to appeal, and the trust obviously had been the driving force at the earlier stage. The court will have seen from the earlier decision. In any event, the application from the Review Tribunal raises the point that arises from paragraph 20 of the Court of Appeal's judgment.
Yes, I see what
and
paragraphs 724 and 725.
Yes.
Yeah.
So the issue,
So you
just
dispute whether
the
the
ease
issue
of
was
all,
actually raised.
the ease of all concern, my Lord, we make the point that the Court of Appeal was in error on that point.
At best, the Court of Appeal dealt with the issue without any submissions, and at worst, they didn't give the parties notice that they were going to deal with the issue at all.
Yes, I think that's right, my Lord. Yes. Do you want to say anything else? My Lords and ladies, unless there are any other points, I could assist the Court with. Those are our submissions.
Thank you very much, Mr. McMillan. Yes, Ms. McLean.
Yes. Lords and ladies, first on a factual point raised by Lord Stevens in respect of the change of language from Secretary of State to Department in the legislation. The instrument that gives effect to that is the Devolution of Policing and Justice, Northern Ireland Order 2010. Article
Devolution
4
of what justice?
of Policing and Justice, Northern Ireland Order
Policing.
2010. It's known as the Devolution Order, and it's Article 4.
Sorry, I meant to give you that.
Schedule 1, Paragraph 11 of that, which refers to the Mental Health 1986 Order, and for Secretary of State substitutes Department of Justice.
Could we, again, if it would be helpful if we could be sent a copy of it?
Yes, I'll attend to that now.
So the statutes revised haven't quite caught up with that
No.
since 2010 to 2023. Yes.
At least we've been of service in that regard, but that's the position which updates that provision. In terms of the reply to the submissions of the respondent, firstly, I take from the oral submissions that the respondent patient doesn't seek to support the Court of Appeal's analysis that there is a differential approach warranted in respect of the legislation, which is key to the Court of Appeal's reasoning. That's not supported, and indeed it's not surprising that it wasn't supported, because the position adopted by the patient in the High Court was to similar effect. I'll give you reference to Section 20, or Paragraph 20 of the High Court skeleton, and also in the Court of Appeal, the written submissions made on behalf of the patient there, and I'll give you the reference for this in the bundle at 333, 334. Paragraph 7 of the written submission recorded the argument that there was no material difference between the Section 32 and Article 77 provisions, and that's been the position adopted by the patient throughout. So no support for the Court of Appeal's analysis from the respondent in that respect, and that's, of course, important. The respondent's position essentially has been, and has been from the outset, that there is parity in respect of the statutory schemes, because the patient seeks to rely on the English case law to make the connection with the hospital point, and that's been the thrust of it. And that takes, of course, the patient into arguments which are largely focused on the factual issues in the case, rather than the legal questions which we say are critically important. In respect of the legal submissions that are made about the statutory scheme, one of the particularly problematic aspects of the Court of Appeal's judgment is found in paragraph 38, which has just been shown again. And in essence, what the Court of Appeal are saying there is that the possibility of a grant of leave of absence, Article 15 leave of absence, should not have any bearing on the decision of the tribunal as to whether detention for medical treatment is warranted. So it should play no part in the discharge analysis. That's what the Court of Appeal have said, and they make the point twice in paragraph 38. That's a problematic finding, because essentially it means that one of the essential elements of the statutory scheme, the possibility of Article 15 leave, is to be left out of account at that juncture. We say that can't be right when one reads Section 30, Article 37 correctly, and I'll ask the Court to look to it again. Article 77, 781. bundle. Now, I've yesterday highlighted the broad symmetry that operates in this statutory scheme and in the English statutory scheme, so that the conditions for coming in to the system are reflected imperfectly, except on the way out. So there's a broad symmetry that operates there.
And just on that, it did seem to me that my Lord Stevens was right to say that going in, it's actual detention. It's a medical person giving an opinion that someone does need to be detained in hospital that provides the authority for the hospital to detain.
Yes.
And do you agree,
I agree with that? And again, that in turn reflects the fact that at the admission or assessment for treatment stage, you will usually be dealing with an acute presentation, someone who has a fairly significant mental illness such that it warrants inpatient detention. So at the acute phase, that's how matters are considered. When one's in the system for a period of time, and it's temporarily limited by the statute itself, it's possible that you will remain acute in a florid phase of mental illness, or that you may move into a chronic phase, or you may be being treated effectively. So when one comes to the Article 77 test, there is potentially at least uncertainty about whether the person remains in the acute phase, whether they're in a chronic condition, or whether they're under control and conditions are no longer met. So there is uncertainty at that juncture. And you'll see the statutory language reflects that, because there's a judgment to be formed by the tribunal. They must be satisfied, so the evaluative judgment, that the person is then suffering from mental illness. So the temporal conditions have changed. You've moved beyond the acute phase. You're now admitted, and the tribunal has to make a judgment of whether or not they are then in the same position or have matters changed. Now, one of the integral features of that judgment-making process is reflected in Article 77.2, and I think I highlighted this to the court yesterday. So a tribunal contemplating whether discharge is appropriate or not can obviously discharge, but an alternative is, with a view to facilitating discharge on a future date, recommend that it be granted leave of absence or transferred to another hospital or into guardianship. And what's the purpose of that? The purpose of that is to allow the tribunal to address the uncertainty by using the leave of absence tool to test the individual in various ways in the community with various treatment components. And when they're in that position, of course, looking back to Article 15 and how it's meant to work, you'll see that at page 735 of the bundle. All of this, the Article 15 leave of absence from hospital, it's from hospital. The connection is maintained by the concept. It's under the superintendence of the responsible medical officer, who under Article 15.5 can at any time, if he considers it necessary to do so in the interest of the patient's health or safety in respect of others, revoke the leave of absence and recall that person to hospital. So our submission is it cannot be right for the Northern Ireland Court of Appeal to say you leave out of account in the discharge analysis the possibility of Article 15 leave of absence.
Well, I'm not sure that, because in Article 77.2, the power to do those things in 2A and 2B only arises where the tribunal does not direct the discharge of the patient.
Yes.
So don't they have to have decided that the discharge is not justified before those powers arise?
I think that compartmentalisation is likely to render the scheme ineffective, because if you compartmentalise that and leave certain key things out of account, then you cannot use the tools that are at the disposal of the tribunal or the clinicians in the exercise of their powers. And that links to a question which the lady Lady Rose asked yesterday about whether or not you can factor in possible conditions or possible Article 15 leave in respect of the process you're involved in Section 77. And in our submission, it is entirely proper for the tribunal to do that, particularly in respect of a Part 3 restricted patient. That's what we're dealing with here. And again, if I can just take the court to why I say that's the case. If you turn to Article 44, which is a provision that allows for the making of the hospital order, and looks to the conditions that are involved there, and that's at Article 44.2, page 760.
This is to do with making of the hospital order following conviction.
Yes. Although the court knows where it's an unfit to plead case, it's a deeming effect, so we operate as if that's been done. But the two conditions you'll see there are set out at A and B. A reflects the one we've seen frequently about warranting detention in hospital. B, the court is of the opinion, having regard to all the circumstances, including the nature of the offence, the character and antecedents of the offender, and to the other available methods of dealing with him, that the most suitable means of dealing with the case is by means of a hospital order. So when you're making the order to detain a Part 3 patient, you have to have regard to the circumstances of the offence, nature of the offender, and the other available methods of dealing with him. That's one of the key factors. When you come to look at the restriction order, which is often the complementary component of the order that's made in these cases, you'll see again that the power to make the order is set out at Article 47, page 764. 47.1a refers to the hospital order. 47.1b, it appears that the court, having regard to the nature of the offence, the antecedents of the person, and the risk of his committing further offences if said at large, that it's necessary for the protection of the public from serious harm to do so. And again, you'll see 47.2, subsection C, allows for, when a restrictions order is made, that the Article 15 facility is engaged, and that's part and parcel of the process. So when one comes then to consider a discharge application for a restricted patient, like this patient, and going back to EF 781, you'll see the Article 77 power, and this is the same with the English provision, Section 72. The Article 77 power is discharge of patients, and it's dealing with, in its text here, not with the restricted order patients. And you'll see the option is to consider whether or not the patient be discharged. So that's what you're looking at. Where you have a restricted order patient, you go over the page to 78, you'll see what's in contemplation is whether or not there should be not just discharge, but whether absolute discharge or conditional discharge. And you're applying, you'll see through 78.1a, the paragraph 1a or b factors in Article 77. So in order to properly exercise that function, and bearing in mind what's in play in the making of the hospital order and the making of the restriction order, and bearing in mind that the tribunal has to make a determination on whether it's discharge, it's detention, absolute discharge or conditional discharge, we say it would be entirely appropriate to take into account the availability of Article 15 leave and indeed the possibility of making conditions at the point when the decision is made. Because the feature that's important here is dealing with a restricted patient. The tribunal has to turn its mind to whether or not conditional discharge is appropriate, whether or not absolute discharge is appropriate, and it cannot properly do that without reflecting on what conditions might be in play. And similarly, as I've outlined, Article 15 is one of the tools in this framework, and the tribunal, particularly with a restricted order patient, will want to consider whether or not Article 15 leave is appropriate in making the determination on discharge, because the conclusion might be we're not discharging, it's not a conditional discharge, It's not going to be detention, but what we will do is test you in the community with the possibility of recall. All of that fits entirely coherently with the statutory scheme. Nothing, we say, that abrades with the statutory purpose. And in fact, it's a means of giving effect to the statutory purpose. The problem with our Court of Appeal's decision, even in a restricted order patient case, they're saying, no, you can't consider the possibility of Article 15 leave. And we say that has to be wrong when one properly analyses the statutory framework. There are other reasons why it is wrong, aside from the text of the statute. It would result in a situation where the tribunal is making these determinations with clinical input that is necessarily not forward-facing. So it's not going to be prospective. You're just talking, the clinical opinion will be about what it is at the time, and what is needed is a prospective analysis. What will happen to this patient in the future, because we're looking at him at this moment, and how can that risk be controlled? And that has to be informed by clinical opinions on management, conditions, and the prospect of Article 15 leave. And
certainly for my part, I don't think you need to delve into restricted orders, because under Article 77, there must always be consideration of what the future plans are for the patient, whether it's a civil patient or a patient involved in the criminal proceedings. And indeed, under Article 77(1)(a), the tribunal could take into account the potential for Article 15 leave, and then they wouldn't have to exercise their discretion under Article 77(2) to make a recommendation. So if it was planned to have Article 15 leave, they would take it into account. And so, I mean, I at present do not see why one has to struggle through a special position for restricted patients.
No, and, it's not essential to make the point, Lord, but it is consistent, entirely consistent with the point. And when we analyse this statute and how it operates, you'll see how it is actually quite carefully crafted to have broad symmetry, the same criteria be considered on the way in, and then gradually being disengaged on the way out to allow for liberty. It's the submissions I'm making are stepping back are consistent with that. And what is obvious is that our Court of Appeal's analysis isn't, and it requires to be corrected, not least because these findings in respect of Article 15 leave read across exactly to Section 17, 72 and 73, if our other submission is correct, that there's equivalence and parity between the statutory schemes. So it is a matter, we say, of some importance.
But is there the possibility of the tribunal in an Article 78 application of someone who's subject to restricted orders, suppose the tribunal comes to the view that actually guardianship would be a good idea? Is that a possibility for such a person, or only for a civil person under 77?
There's no facility, subject to correction by my juniors here, I think there's no facility for guardianship arrangements for restricted patients under 78. So
50A 2B, page 768.
I think it's an alternative. Yeah, I think that's an alternative sentencing disposal by way of a guardian. It's not a. It's not the. If you're in restricted order, that's not the outcome.
Sorry, I missed that answer. That's not available if it's a restricted order.
That's an alternative sentencing disposal.
I see.
Court can make a guardianship order.
Sorry, I missed the page number. What was
That's 768.
You must indeed.
So In terms of our reply to the case that's made, we say the patient's position doesn't attack the fundamental error we say the Court of Appeal raised, insofar as there is support for the leaving out of account of Article 15 leave. We say that's not consistent with the statutory scheme. In terms of the case law and its applicability on the questions that have been raised about connection, those are broadly factual questions, and we say even if that is the analysis has got to be deployed, and we don't really agree that it is, then looking at the evidence, only at the evidence found in paragraph 10 of the Court of Appeal's determination, that would satisfy the requirements in any event. It's clearly the case that this patient was to be subject to supervision and management led by the RMO, who was at the beginning, middle and end of that process. So on that point, even on the facts, which we say is not the appropriate paradigm for this appeal in any event, we say the respondent's arguments are not compelling. Lord Stevens asked why there are so many appellants. There are only two, Lord, but the peculiar feature of this case is it's a judicial review application against the review tribunal, who was the proper contradictor in the High Court proceedings, provided the evidence, made the arguments, and ultimately succeeded. When the case got to the Court of Appeal, I think the Court of Appeal judges only permitted the department to make written submissions, curiously, because in one view the department is the better respondent. So the case was defended by the tribunal in the Court of Appeal, and in fact they had an adverse costs order against them. So they were the responding party and the party with the appeal rights. The department are the notice party appellant, and as custodians of the legislation are the order. Happily, I appear for both, and there isn't any conflict between us, and hopefully we've presented the points economically. But it's again
usually a judicially reviewed tribunal maintains a dignified silence.
Yes,
but
the decision
speaks for itself.
Speaks for itself.
Yes, I recognise that. But again, it's the way in which this litigation has unfolded. It is important that the department are here making these submissions, the combative submissions on the part of the legal argument that applies, because it's the department that has the interest in the overarching interest in the correct legal analysis. So that's an explanation.
One of the issues that arose in the Jordan litigation.
Yes.
And there are a number of Court of Appeal authorities in Northern Ireland.
And there are circumstances
on the circumstances in which a tribunal should appeal and make submissions.
They're not shut out entirely, but it's more an artefact of the way in which this litigation unfolded and the curious approach the Court of Appeal took to closing out the department, essentially, on oral submissions. But I hope it hasn't impeded the efficient consideration of the case. My Lords, Lady Innes.
Could I, before you finish, I postulated a potential test, and I'd be very grateful if you could alert us to any dangers of such a test.
Yes.
Any.
My Lord was posing a test in respect of the application of Article 77(1) and raising one of the possible concerns being unanticipated collateral impact on, for example, patients who weren't taking treatment or weren't taking treatment. Now, again, bearing in mind how the scheme is meant to work, Hallstrom, Barking, etc., pretty clear authority that you can't be admitting someone into the system just because they're not taking their medication. So it's not a ground for coming in under Article 4 or Article 12. That's an abuse of the legislation. If you admit someone who doesn't need inpatient treatment just to make them take medication, that's not a way into the system. So if you're in the system, that's not why you're there. It's possible that, as I said, you've come in as an acute admission, your symptoms become controlled or latent, and now you're about to be tested on an Article 15 leave. When you're in that position and someone's going out, And the problem is that they simply won't take the largactyl and may become florid again. That's not a problem with my Lord's test, because the answer to that is Article 15.5. That's the mechanism that brings you back in again. Because the RMO is the superintendent of all of this. So, and again, this is a power that can only be used to people who've been properly admitted to the scheme in the first place, i.e. acute on the way in, latent or controlled, now going out on leave of absence. And if it goes wrong, as it may well do, then Article 15.5 allows them to be retrieved back to get the proper care and treatment.
But the difficulty is that if you're a detained patient, you can be compelled to take medication, and you can be compelled to receive various forms of treatment.
Yes.
And
But if you're on leave of absence, one of the conditions, if you like, of the leave of absence would be compliance with the treatment regime. And if there's non-compliance with the treatment regime, alarm bells ring. RMO said, well, that looks like a case for in your interests, which I think is one of the criteria in Article 15.5. You come back into the system.
Yeah, one might think that that's a fairly standard use of Article 15,
yes,
because you're really looking to see whether the person can be relied upon themselves to take the medication that will control their condition.
And if they
can, great.
Yes.
If they can't, they need more help and in detention.
That's why this analysis is actually copper fastens to the point about the need to have access to Article 15 as a tool in this environment. You need to have it to test people for exactly those reasons. And it's in the interests of the patient to strike the right balance between deprivation of liberty, protecting the public and their interests, that you do use it in order to achieve that outcome. So the levers are there when we analyse it properly to allow Article 15 leave to be used in a way that actually doesn't create the difficulty my Lord was concerned about.
But I think your answer says that it does, because you're saying that you can recall somebody under Article 15 leave for reasons which would not be good enough to admit them into hospital in the first place.
Yeah, that's not a problem, because they've been admitted for other reasons. Now they're in the system. The question is, can we get them back out again? So it's not a difficulty.
It wouldn't also depend on Article 15 leave, because the test that I was proposing would be under Article 77. They need to take the medication. They're not going to take the medication unless they're detained, and that's a justification for not making the order, and then immediately granting them Article 15 leave. And during the course of that, they are compelled to take their medication. And so it's a method of compelling them to take their medication.
Yes.
And there are vast numbers of people, I would rather suspect, who don't take the medication.
Yes. But most of them will not be admitted as acute conditions.
The only control on that is the necessity test. So there was a strict necessity in relation to the dangers of them not doing so.
Yes.
For themselves and for others.
Is there somewhere where we have an up-to-date account of what has happened to RM since the tribunal hearing, where he has been? And
there's nothing in the papers. We could attempt to agree a factual chronology on that for the court if you wanted to have that.
I think just the dates of where he's been and when might be helpful. Because it's something on which Mr. Macmillan has placed some emphasis during the course of his submission.
I have a working chronology of that without commentary, which I will share with my own friend and see if we can agree it. I think it's not a document to be scoring forensic points on, but we should be
just as a factual.
The factual account.
And we have now received some of the documents that were promised. There are some others to come. If you could let us have all the material within the next week, that would be very helpful.
I'll do that. My Lord Millise, those are my submissions to reply.
Well, thank you very much, Ms. McGleenan. Thank you. Thank you to all counsel and those sitting behind for all the assistance we've received. We'll obviously take time to consider what we've heard and let you have our judgment in due course.